Okay, go ahead.
Okay. I guess I need to, okay. So I'm going to start by reading our nonpartisan statement. The League acts in support of or in opposition to selected governmental issues which its members have studied. It does not support or oppose candidates, factions, or political parties. League members, as individuals, are urged to work in the political party of their choice. To protect the League's nonpartisanship policy, guidelines regarding the political activities of the Board of Directors are reviewed frequently. The League of Women Voters of Pullman is fully committed to diversity, equity, and inclusion in principle and practice. These concepts are central to our current and future success in engaging all individuals, households, communities, and policymakers in creating a more perfect democracy. We acknowledge and honor the first people of the Palouse region and their descendants, including our neighbors, the Nez Perce, Colville, and Coeur d'Alene tribes. And I'd like to welcome you all to this presentation. And I'm going to introduce our speaker. The Pullman League of Women Voters is committed to civics education, including issues involving Native American sovereignty and the impact of recent and ongoing Supreme Court decisions on tribal issues. For this reason, we have invited Professor Neoshia Roemer to address these. She is an assistant professor at the University of Idaho College of Law, where she teaches family law. Her areas of interest include domestic violence, child welfare, LGBTQ issues, and the Indian Child Welfare Act. Prior to joining the faculty at Idaho, she worked as the fellow and later staff attorney for the Indigenous Law and Policy Center at the Michigan State University College of Law. There, she mentored first-year American Indian law students, worked on appellate litigation involving the Indian Child Welfare Act, and coached moot court, among various other tasks. So we welcome Neoshia tonight, and we are going to approach this a little bit conversationally, so we will take your questions. If you want to put them in the chat, Carolyn's going to monitor the chat. Or if you want to wave your hand at us or do your hand down at the bottom. And so with that, we will turn this over to Neoshia.
Thank you so much. I just wanted to start off by saying, having heard the nonpartisan statement first, and being asked here to talk about Indian law, in particular things that impact tribal sovereignty currently, I just wanted to mention at the outset of this that in terms of things being nonpartisan, Indian law is one of the few areas that is rather nonpartisan in terms of this is something that I think I can say all political parties tend to work in these issues because Indian law is something that exists because of our relations to the peoples indigenous to America, indigenous to the lands we live on, and things like that. So I will admit, I prepared quite a few slides that get into the introductory nuts and bolts of Indian law. I'm happy to sort of gloss over those, skip over those. If folks are like, hey, I already know all this, let's talk about the meat of the presentation. You all just let me know. It's just my experience that having some understanding around the talking points and understanding what we're talking about and having definitions is very important in these conversations. So in terms, can everyone see my screen okay, or is everyone seeing the boxes on the side? Okay. Mm-hmm. So in terms of things that I want to use, or terms that I will be using this evening, the word Indigenous, Native American, American Indian, they all mean the same thing for our purposes in the United States. But tonight you will hear me say American Indian or Indian quite a bit. And the reason that I am using that language is because that is the legal definition that we're talking about. And I know, when I was coming up, sometimes we were told that to say Indian might be derogatory. But I just wanted to highlight that the reason I use the phrase Indian law or American Indian or Indian is simply because that's the legal definition in the federal statutes. And also, you'll hear me talk quite a bit tonight about Indian country. Indian country is essentially tribal lands, so reservation lands that exist all throughout the United States. So I love that we started our introduction off with whose lands we're currently situated on, because that's very important to think about that, because we are all on Indian land. Anywhere you set foot in the United States is effectively Indian land. And so this is a map of Indian lands and nations prior to the arrival of settlers. And I would also draw your attention to the fact that in Washington state, we have 29 Indian tribes. Now, Nez Perce and Coeur d'Alene are both in Idaho, or, sort of where we drew that arbitrary state line, if you will. But we do have 29 different tribes in Washington state that have land bases here. And you'll notice from this map that a lot of those tribes exist in the western part of the state. But in total, we have 574 federally recognized tribes in the United States. There's actually more than 574 tribes. Those are just the ones that have federal recognition and a special relationship with the United States government. There are some tribes that have what's called state recognition, meaning that the state in which they sit in recognize that they're an Indian tribe, but those tribes don't have a special relationship with the federal government. Why that matters? Well, when we talk about Indian law, we are primarily talking about federally recognized tribes who all predate the United States and the US Constitution. The fact that tribes predate the United States is probably, that's probably a pretty easy point to make. I think most people understand that point. But the fact that they predate the US Constitution, right? So the US Constitution comes in the late 18th century. Tribes predate the Constitution. So what does that mean about tribes? Well, a lot of different interesting, well, not a lot, but a few different interesting things. One, there is a provision in the Constitution that is colloquially, we call that the Indian Commerce Clause. And through that provision, that is how Congress has its relationship with these federally recognized tribes. Congress has what we call plenary authority over tribes, meaning that Congress is the only body in the United States that can make laws pertaining to Indian tribes. Another thing about the Constitution and Indian tribes is that as to tribal court, anything that happens on tribal lands, the US Constitution doesn't typically apply in those cases. And I actually will talk a little bit more about that coming up. But what's also important to understand is that because tribes predate the US Constitution, the US government, Indian tribes are sovereign governments, meaning they are dependent nations. We use the word tribe, and actually some tribes do, in their titles or proper names, use the word nation, because they are a separate government. And with that sovereignty comes the right of self-determination to make laws governing one's tribal members on those lands and things like that. Now, one of the stickier parts of Indian law is what we call jurisdiction. And the reason I kind of throw this out there is that jurisdiction in Indian country at large, the way I describe it to folks is kind of like a checkerboard, and we have a lot of questions to answer about it. Now, I will talk some tonight about jurisdiction, but I won't get into the nitty details unless I have to in answering a question, because we literally spend weeks talking about jurisdiction in Indian law. We talk about jurisdiction in other places of the law. But what's important to understand about this is that with regard to tribal lands, tribes have full authority to make laws governing their members on tribal lands. They have the ability to conduct a government-to-government relationship with the federal government. And that's because the federal government owes a trust responsibility to Indian tribes. So meaning the federal government has a duty to act responsible, act as a trustee for Indian tribes. Over the years, this has meant a lot of different things. It's a theory that we still use, and we actually use this when we talk about the Indian Child Welfare Act and why Congress passed that act in the first place. But it's important to just sort of understand when we talk about Indian tribes and sovereignty, we are talking about sovereign, independent nations. But sort of the rub or the push and pull, if you will, of this government-to-government relationship with the United States is that tribes are considered domestic dependent nations, meaning there is that relationship, meaning that Congress has acted in ways to limit tribal sovereignty. And I really try to be very clear about this point because tribes are full sovereigns, but it's this outside pressure, the federal government, Congress, and Supreme Court decisions as well, that have acted to limit how tribes can use their sovereignty in certain circumstances. The number one circumstance would be in the area of criminal law, in terms of how tribes can prosecute crimes, who can prosecute which crimes, different sentencing things and things like that, which we will also talk about here in a little bit. Are there any questions so far? Okay. So what Indian law covers? So we're talking tribal lands and Indian country. So jurisdiction to prosecute crimes that happen on these lands. Again, like I said, jurisdiction is one of those things. It's a bit complicated in the sense that when we start talking about jurisdiction in Indian country, the guiding question is who did what to whom on whose land? Because we have to assess, was there a victim? If so, was that victim Indian? Was the defendant Indian? Is this a civil or a criminal issue? There's so many questions and layers that have to be answered. But Indian law definitely covers this. It also provides this mechanism for tribal, state, and federal interactions. Now, as I did mention, Congress has what we call plenary authority over Indian tribes, meaning that Congress is the only body who can legislate, make laws pertaining to Indian tribes. But what we see, because, we now live in a country that has 50 separate states, and some of those states, particularly in the Western US, where we're currently sitting, have quite a bit more interaction and involvement with their Indian lands. So what we sometimes see are states trying to pass laws, for example, trying to tax tribal members who live on tribal lands, which states cannot do. But that's just sort of an example of, how some states sometimes want to become more involved with Indian lands. And we see the Supreme Court answer this question time and time again with this balancing of tribal, state, and federal interactions because of this guiding principle that Congress alone can regulate or can make rules pertaining to Indian tribes. So in terms of legal topics, Indian law, it sounds like it's this one basic area of law. It actually covers a lot of things. So gaming law, criminal law, land use and management, natural resource extraction, and gender-based violence, and the Indian Child Welfare Act. So for tonight, I know I was called upon probably to speak to the Holland versus Brackeen case, which is a Supreme Court case about the Indian Child Welfare Act, which I will get to. But I would also like to spend a little bit of time talking about some updates to the Violence Against Women Act, which definitely impact sovereignty as well. These changes just went into effect on October 1, 2022. And then also the Indian Child Welfare Act. But I would also encourage you to think about this point, which is when we're talking about Indian law, we are talking about this push and pull between the federal government and tribal governments. But also Indian law exists to promote self-determination of Indian tribes. There have been periods historically where Indian law was about assimilating Indian peoples, about getting rid of Indian tribes, and various other things that had to do with settling lands, getting lands, all of those different things, and ending that relationship. But today, when we're talking about Indian law, at the crux of Indian law is this promotion of self-determination, meaning, self-governance and what tribes can do to govern themselves. And I mean, tribes are doing that. So I like to highlight the positive and what's going on, because I think sometimes when we talk about Indian law and tribal sovereignty, we sometimes paint a picture of this extremely downtrodden group, which historically and contemporarily, I think that there are problems that exist of that nature. But I really want to highlight that we're talking about a story of self-determination, resilience, empowerment, and that's what things like the Indian Child Welfare Act is about in terms of getting members back to tribes. And again, we'll talk about that a little bit more later. But at the heart of everything we're talking about tonight is this self-determination, the ability to self-govern. And as I mentioned, sometimes federal policy limits what self-determination looks like. The biggest example of that is in the criminal context. And we are going to go ahead and get into the Violence Against Women Act. I do want to let you all know, I do have some statistics that I'm going to share that mention incidences of sexual assault and domestic violence. So I just don't want to spring those on you. But this is also an area in which Congress, well, actually more of the Supreme Court, in a 1978 decision that actually originated from Washington State, actually limited how tribes can prosecute non-Indians who offend in Indian country. So the best way I can describe this is, if we're sitting in Pullman, let's say I'm a resident of Pullman. As a resident of Pullman, I drive into Moscow every single day. I cross the state line with the expectation that if I'm speeding across the state line, if I commit a crime in Idaho, that someone from the city of Moscow or from the county could feasibly file charges against me. And I would be held accountable for those charges if I broke the law. Well, the way that jurisdiction has typically worked in Indian country, at least since 1978, there's this whole entire analysis of whether or not the defendant is Indian. If the defendant's not Indian, tribes, generally speaking, don't have prosecution, do not have jurisdiction to prosecute that person. And why did I just sort of jump into criminal law land when talking about violence against women? Criminal jurisdiction, the ability to keep one's community safe, is a very, very important deal in this particular context. And limiting criminal jurisdiction, limiting the access to prosecution over a certain type of defendant has really impeded tribal sovereignty in the sense that tribes can't keep their community safe. And I see I have a question. Indian law, is this an overreaching concept, or can it refer also to individual tribes or reservations? That's a great question. So this is actually the field of federal Indian law is an overarching field. So let's say we have a case out of Coeur d'Alene that goes to a federal court, and the federal court makes a decision in that case. That decision could potentially impact all 574 tribes. Now, each tribe as a sovereign government, because they're sovereign nations as a sovereign government, have their own tribal codes, their own laws that they use to self-govern. Indian law specifically refers to this relationship that each tribe holds with the federal government. Did I answer the question?
Mm-hmm.
Okay.
Mm-hmm.
So jumping back into sort of into violence against women in Indian country, I think there's some really important statistics that we need to understand, especially given where we sit. So 84% of all American Indian women have faced violence in their lifetimes. 56% of all American Indian women have been sexually assaulted in their lifetimes. I believe the number is about 33% of all American Indian women have been raped in their lifetime. 40% of all American Indian women will face domestic violence in their lifetime. The murder rate for American Indian women is estimated to be 10 times that of non-Indian women. And as of 2016, nearly 5,712 American Indian women have been reported missing. So I give you these numbers, but I have to explain to you a couple of things that make these numbers stand out. First of all, as of the 2020 census, American Indians are approximately 2% of the US population total. Mm-hmm. 2% of the population total. These statistics that I have, these actually come from a combination of congressional findings and government agency reports and nonprofit reports. But these statistics vary wildly across different reservations, across the country as a whole, and also whether or not the person we're talking about is in an urban area or if they are in or if they are on reservation. And many reservations do tend to be in fairly rural areas. I mentioned the urban areas because today, somewhere around 70% of all American Indian peoples live off reservation. And that is important so that we move forward in this conversation in a way that's productive. I want to highlight that these numbers don't merely indicate one of the biggest myths that exist about American Indians, which is that reservations are just very, very dangerous places. That is not at all what these numbers say, especially considering that over 2/3 of all American Indians actually live in urban areas. These numbers, they can vary across the board as well. Does anyone have any particular questions about these statistics or what they, or any of that sort of context before we do move on?
I find them shocking, but
I would say I have a background like 30 years ago. I worked for the Indian Health Service. Mm-hmm. And this was in Nevada. And there's a colony, Indian colony in Reno. And then there are multiple reservations around that area. And it seemed to me just overall, our experience was that in the colony in Reno, there were just more employment opportunities. And it made a huge difference in terms of the things that we saw health-wise, mm-hmm. of just the ability to have places to work. And I think that really impacted the violence we saw and the alcoholism we saw. So that's just kind of what I don't know if there's statistics to prove that. That was my personal experience looking in.
Interestingly enough, so the missing women number that I have here, mm-hmm. The reason I included that is that there is an epidemic of missing and murdered Indigenous persons. largely missing for a variety of reasons. There's a lot of conspiracies, or I shouldn't say conspiracies, but there's a lot of theories about what have happened to these people who've gone missing, people who just turn up dead. And there's not much, it's hard to get jurisdictions to talk to each other, leading into some of those problems. But the reason I mention that is, I believe it's Urban Indian Health actually did a study on missing and murdered Indigenous persons in urban areas. And they did find similar differences between, folks who lived in urban areas who were impacted by this violence and folks who lived on reservation. And the other thing that I would add, and I do see your hand, the other thing I would add quickly too, is that in the 1950s, I believe 54 or 56, the federal government, Congress, passed a statute that authorized the Bureau of Indian Affairs, which is the agency that has historically administered programs to all of Indian country, authorized this program called the Federal Relocation Program, which is one of the reasons so many American Indians now live off reservation, because families, American Indian families, would visit the office on the reservation, and they would seek out employment, because that was the program, that was the purpose, was at that time, the economy's booming. We have cities in the north, like the whole Rust Belt area, Detroit, Cleveland, all those places. We have like Los Angeles, Oakland, those urban areas, the Indian population blew up quickly. And that is one of the reasons so many American Indians live off reservation, is because of that program. The reasons behind it aren't quite so, how should I put this? They're not quite so positive, because part of that was to purposefully get Indians off the reservation, to cut cultural ties. And it was one of the ways in which the federal government thought they could eventually destabilize Indian tribes, and terminate those relationships, those government to government relationships. Yes, please go ahead.
If that's a question for me.
Oh, yeah, you have your hand up.
Yes, I have. This is Alex Hammond. I don't, my screen doesn't seem to be able to look at me and you at the same time. Just a couple things about, two questions relative to the statistics. And the first goes back to the issue of tribal sovereignty. And at some point, I'd love you to address the issue of how an Indian is defined in terms of bloodlines and heritage. And the second is relative to that kind of these statistics here. Might you clarify, when you're looking at the 56% of all Indian women, are you dividing that by urban and rural, or are you dividing that primarily by reservation and non-reservation? Those are the questions.
Okay, yeah. So to tackle the first question, American Indian ancestry, or that label, can be defined in two ways. So first is probably the way that we're all familiar with, which is when you get a form in the mail and they ask you what race you are. And you say, I am this race, and I check the box. So that's one way, but it's not the way. And what I mean by that is anyone can self-identify as any race. But in terms of American Indian, who we are talking about, the legal definition that we are talking about, is someone who is enrolled in a federally recognized tribe, meaning they have a tribal membership card, meaning they might have what's called a certificate of Indian blood from the Bureau of Indian Affairs, but they are enrolled in a tribe, that they have what we call a political status. Think of political status in terms of citizenship. As an American, you enjoy a political status as an American. American's not a race, it's a political status. So that is what we're talking about in terms of American Indian and what that definition is. Now, in terms of bloodlines and heritage, that gets us into a dicey place, And the reason the place is dicey is because of tribal sovereignty, every tribe has the ability to define its own membership. There was a Supreme Court case in the 1970s, in which one tribe in New Mexico actually said that they were not going to enroll the children of female members who had fathers who were not members of the tribe. And now one female member sued the tribe and said that's not fair because of equal protection of the laws. You can't discriminate because I'm a woman who have these kids. How am I any different than a man? And the Supreme Court said, well, actually, because of tribal sovereignty, they can determine their membership. They have the ability to determine their own membership without any sort of oversight. Now, historically, that's actually less true than what it is today. Because I mentioned the certificate of Indian blood that the Bureau of Indian Affairs can issue. But historically, when Ames were to, I like to compare this to African Americans. So for African Americans historically, there was the one drop rule, meaning if you had one drop of African blood, you were Black. And that served the purposes of what the policy was, to have more slaves. But for American Indians, it went the other way. Because as you had less blood, we wanted to quantify your blood, because as you had less blood, then you were less Indian. And then eventually you weren't Indian anymore, or your children weren't Indian anymore. And so that was one way to sort of decrease the population. So this is all to say this. We get a lot of interesting questions about how does blood quantum work and things like that. And so first off, I would say not every tribe uses blood quantum to make decisions on membership. It might be as simple as, who are your ancestors and are they members? And some tribes still use blood quantum, which comes from the old days, old federal policies in terms of determining who their members are. But to be very clear, American Indian in this case is only people who are enrolled in a federally recognized tribe. This does not incorporate or include people who might self-identify as American Indian. Unfortunately, it might also not include people who are what we call descendants, meaning that they don't meet the tribe's requirements for enrollment, but perhaps they have a parent who is a tribal member. And so they're still culturally linked to that tribe, but they don't have the official membership piece. They don't have the official political status. Now, in terms of these statistics, I'm not entirely sure if they did the urban rural breakdown here, but my understanding is that these numbers actually came from Indian Health or from a study that Indian Health Services conducted. So these, just to be clear in terms of these numbers right here, I don't have a good sense of urban versus rural breakdown.
Thank you.
So why this problem exists? This gets into that jurisdiction problem that I kind of started to talk about and veered away from just a little bit. Again, it's not that reservations are inherently more dangerous than other areas, but American Indian women have a specific or a unique pattern, shall we say. So for most of these types of crimes, things like domestic violence, sexual assault, the criminal patterns are usually such that crime exists intra-racially within the race. In terms of American Indian women, the pattern is that this crime happens interracially. And why that is, I think there's several different theories as to why that is. But over the years, federal Indian policy has limited how tribes can deal with interracial violence. So for example, if you are a tribe who has a non-Indian person on your lands, and they sexually assault one of your members, you may not be able to prosecute them. You can call the state to come pick them up. You could even call the feds. Whether or not that person gets prosecuted is a huge open question. because even in 2023, I actually am on the Idaho State Tribal Forum and have participated in some of the programming that Coeur d'Alene has offered, such as the Missing and Murdered Indigenous Women Conference last May. But even in 2023, there's still lots of questions surrounding, I have this situation happen, who do I call? Because I'm a tribal police officer and I don't think I can arrest this non-Indian person. So a lot of these crimes actually just slide through the cracks without prosecution. In 2013, when Congress was considering the Violence Against Women Act, or not considering, but prior to passing the Violence Against Women Act in 2013, one of the findings that Congress made in hearing testimony and evidence about this was that the U.S. attorney, who is responsible for prosecuting these types of crimes, had declined somewhere around 50% of all these cases. So they had declined to prosecute in about 50% or more of these cases. So that's a pretty huge, what we call declination rate. But I would also mention this. There is a pattern of this type of violence in remote areas. And I mean, think about Alaska, for example, and just sort of the remoteness of a lot of Alaska. But in remote areas, but also where extractive industries move in, there is a pattern that seems to follow. So oil, mining, that kind of thing. So the federal government's response to this violence, because the federal government has responded, because advocates and activists from a variety of tribal communities have been protesting, advocating that the federal government do something. And the particular something that they want is restoration of tribal sovereignty to allow tribes to pursue these crimes. But here's what the federal government has done. In 2006, the federal government passed what's called the Habitual Offender Statute. And I'll just sort of give you an example of what this does. So say that you have an Indian defendant who has been convicted twice in a tribal court for domestic violence. The third time that they end up with a domestic violence charge, that's an automatic removal to federal court. The federal prosecutor's office, the AUSAs, have jurisdiction to prosecute that. Now, you may be wondering, what is so unique about that? Why is that so different? Well, until 2010, and actually I'll go ahead and put this up. Until 2010, tribes could only sentence an offender to 1 year, up to 1 year in jail. After 2010, it's up to 3 years in jail for each offense, up to 9 years. But tribes can only, in some circumstances even, sentence someone to jail for up to 1 to 3 years. The federal prosecutors, this type of crime is an automatic 5 to 10 year sentence. So it increases the amount of sentencing time. Now you may also be questioning, like, well, what's good about that and what's unique about that? I don't know that I can say there's anything spectacular about it. But what I can say is that it removes that offender from the tribal community. It actually gets them out of the community. Because even though tribes can sentence to up to 1 year in jail, most tribes don't have their own jail. So they usually have to contract with the county that they're in or maybe an adjacent county to actually put people in jail. And it costs a lot of money for their tribe to do that. So sometimes this person may go to jail for a little bit, but they may not be in jail for very long. So the habitual offender statute, by virtue of making it a federal crime, gets that offender out of the community for some time. So the next thing that the federal government did was pass the Tribal Law and Order Act. And as I was saying, this is the act that allows tribes to put people in jail for up to 3 years per crime they commit, up to 9 years. So it increases sentencing, but there's a drawback here. because now tribes have to essentially comport with the Western court model. So think of it this way. I think this is probably the best example. Tribal courts are actually very modern. I don't want to leave you with the impression that tribal courts are not modern, because many of them are. But they are now forced to act like a court that's in the state of Washington in terms of what they can do with offenders, how they prosecute, who's the judge, because culturally speaking, for some tribes, the only person who's ever appropriate to serve as a judge is a community elder. And that depends on the tribe. So I don't want to leave you with the impression that that's every tribe. But if I am a member of a tribe who, and that tribe says it's only ever culturally appropriate for an elder to be a judge in this tribal court, what that means is there is a very low likelihood that their judge is someone who's gone to law school and passed the bar exam. That is very important for using these types of models in tribal court and for what I'm about to tell you next. Because in 2013, when Congress reauthorized the Violence Against Women Act, this actually increased tribes' ability to prosecute non-Indian offenders for crimes, for actually very, very specific crimes that they committed against Indians on the reservation. When I say very specific crimes, I mean specific in that the defendant had to either be an intimate partner, a current intimate partner of the victim, or they had been an intimate partner of the victim. The victim had to be Indian, and it specifically could only be domestic violence. It couldn't be any other, what we call ancillary crimes. So one thing that's common is that police officers are attacked or are somehow injured or harmed through violent activities, or sorry, I did not frame that very well. It's not uncommon for an aggressor to lash out at police officers when they show up to the scene of a domestic violence dispute. Under that very narrow reading of the law, or very, very narrow prescription of the law, a person could only be charged for crimes of domestic violence. They couldn't be charged for, punching a police officer, couldn't be charged for hitting children who were there, none of that, just the domestic violence. But it did open a pathway to prosecute some non-Indian offenders who committed domestic violence against Indian victims. So the reason I bring all this up, because I was asked to speak on some change tribal sovereignty today. As of October 1st, 2022, the Violence Against Women Act was reauthorized. It went 9 years since its last authorization. It's supposed to be authorized every 5 years, but it was reauthorized last year. So there were some important changes. And I don't know if many of you know, but this law has been on the books since 1994. It was the first federal legislation in this area of gender-based violence, because believe it or not, in 1994, domestic violence was not a crime in every state. Marital rape was not a crime in every state. The Violence Against Women Act changed that, and also provided lots of funding that states, local governments, and tribes could actually authorize for programming. So today, a lot of domestic violence shelters, a lot of domestic violence programs, trainings, draw funding because of the Violence Against Women Act and the funds that Congress appropriates to that program. And so, and I think I mentioned the reauthorization piece, and that's actually why it was important to be reauthorized. Because the Violence Against Women Act will always be on the books. It will always be a law unless Congress repeals it completely. But when it doesn't get reauthorized, the funding doesn't get reappropriated. So I think that the executive branch was funneling some money towards this end. But when Congress does not reauthorize VAWA, That's the colloquial term for it. The funding doesn't get refilled. So then that becomes a problem to shelters, for law enforcement. Law enforcement get grants under this as well. And folks who work in this area. Specifically for Indian country. Since 2005, it has actually required a dedicated attorney in each U.S. attorney's office where there's Indian country. So if there's Indian country in your district, and we are in the Eastern District of Washington, because we have tribes here, there is one attorney in that office that actually deals with these crimes specifically. The 2013, as I mentioned, imbued tribes with special criminal jurisdiction over non-Indians in some very rare circumstances. But in 2023, or the 2022 version, that actually expanded the type of crimes that are covered quite a bit. So now things like elder abuse, child abuse, assault on a police officer, a tribe can prosecute a non-Indian offender who commits those acts on the reservation. Doesn't matter if they're in an intimate partner relationship with that person or not. Are there sort of any questions on that end? Go ahead.
So I'm just wondering, if now with this and this expanded prosecution, if someone gets sent to jail, is it still the same thing that the tribe is responsible for paying for their jail time?
Yes.
Okay. So that's, so somehow there needs to be more funding for that or something.
Yes. And that is a great segue, because there is a definitely an or something here, because there are some major critiques to VAWA, primarily in how this forces courts, tribal courts, to become very westernized, because they have to have a judge who is law trained. So they've been to law school, passed the bar. They have to provide public defenders who have passed the bar. They have to have an entire court system. They have to apply the US Constitution in these courts. Because remember earlier I said, oh, US Constitution doesn't apply in tribal courts. Well, to these defendants, it does. It only applies to non-Indian defendants in tribal court. So a lot of the tribal courts have had to seek improvements, really modernize, hire staff and personnel. And yes, there is grant funding under VAWA to hire personnel, to train law enforcement, all of those things. But the jail still remains a problem, not just because, I can only sentence up to 1 year. Culturally speaking, in some tribes, it's not preferred to send people to jail. There are other alternatives that people prefer, but federal legislation, or not, let me be a little bit more clear about that. There are some alternate sentencing, alternatives to prison time, to jail time, that culturally some tribes prefer over this Western put people in jail. Some preferences for rehabilitation programs, if you will. Again, not every tribe, situations differ, could differ on a case-by-case basis, but under VAWA, jail is the answer, which is sort of a problem, or could be a problem in some cases for some tribes, because VAWA provides funding for training. And this is actually not VAWA, but there is another grant for drug prosecutions. And in that grant program, it actually specifies sentencing. One of the things they want to train tribal prosecutors on is advocating for jail time and sentencing. So some of the same punitive measures that you see come across in criminal justice at large, at both the federal and state level, come through in these grant programs and some of the aims and the training and things like that. Now, again, I don't want to oversimplify and say no tribe ever wants to put people in jail, or every tribe always wants people in jail. But as you can imagine, 574 tribes spread across the US. Even in this small group of us, we all probably have differing opinions on this and what should happen. So I just want to briefly talk about this case. It's Oklahoma versus Castro Huerta. This was a Supreme Court case from last year. The decision came out last summer. It was about a week after the major opinion in Dobbs versus Jackson Women's Health. So this is a tribal sovereignty issue. And to sort of give you the cliff notes here, the biggest issue in this case was, can a state prosecute a non-Indian on tribal lands? Because traditionally the answer to that question is no, they cannot. But here's what happened. Or I'm sorry, actually it's Mr. Castro Huerta was an Indian person. So that's a mistype. Traditionally the answer to that question was no. Can a state prosecute an Indian on tribal lands? And yes, the Supreme Court said, yes, they can. And the reason being, there was a case in 2020 called McGirt versus Oklahoma. In that case, this was a major landmark decision because most of Oklahoma, like most of the West, has been settled over the last 100 years. People have moved in, towns came up, all this different stuff. Well, Congress had reserved a lot of land in Oklahoma to Indian tribes because if you recall, historically, Oklahoma was called Indian Territory. That is where Indians who were marched along the Trail of Tears were marched out to Oklahoma. So the Cherokee Nation, Chickasaw Nation, Choctaw Nation, Seminole Indian Nation, and Muskogee Creek Nation were all moved out to Oklahoma from southeastern US. And in doing so, Congress allotted reservation lands. Well, in order for a reservation to be disestablished, which means broken up or terminated, Congress has to actually say that's what they want to do. Well, in this case, Congress never did that. Congress never said we're ending these reservations. So the Supreme Court in McGirt versus Oklahoma said, well, you know what? It's still Indian land. And that was a huge decision because what that meant was functionally 47% of the state of Oklahoma is all Indian country. 47%. That also creates a lot of panic. Because people bought houses, there were towns, there were all these different things that had just come up, right? Because over the years, towns come up, people move places. And so suddenly it's like, wait a minute, who has jurisdiction to prosecute crimes? Who has jurisdiction over child welfare matters? After McGirt, there were some people who had been sentenced for crimes, particularly Indians who the state had prosecuted for crimes, who had to have their sentences reviewed. Only a handful of people actually had their cases completely thrown out because the feds were also reviewing a lot of these cases at the same time, because even if the state didn't have jurisdiction to prosecute, the federal government would have. So Castro Huerta comes about. It's a pretty brutal case in which a young Indian girl, her parents, her mom and stepdad, they abused her. She was disabled and just very mistreated. So the state of Oklahoma prosecuted, but then the stepdad is like, well, theoretically, you do not have jurisdiction in this case. So that's the Castro Huerta case. It's a horrible fact case in terms of, what the case is about. But the question that the Supreme Court has to answer is, can the state prosecute this crime that happened on its tribal land now? We said it's tribal land. And the Supreme Court said yes. But there's a little wordsmithing that kind of becomes a problem. But I just want to also highlight that this is pretty Oklahoma specific because it's responding to an issue in a prior case. But the wordsmithing issue is how it invokes states' rights. Because remember, I told you that Congress has this plenary authority to regulate Indian tribes. And traditionally what that has meant is that states do not have that authority, absent some sort of congressional, some sort of divestment of congressional authority. But in this case, the Supreme Court said, well, because of the 10th Amendment, states have the right to prosecute these cases, and they decided the 10th Amendment, and that was it. So for those of us in Indian law, this is a little scary, but again, it's pretty Oklahoma specific because of this McGirt case. But I did want to highlight that for you all. And it can also impact prosecution of cases like, especially in the realm of violence against women. So any sort of questions on that before I move on quickly? I realize we're at time, and I haven't even reached the Indian Child Welfare Act, but I can get there. Okay, so the Indian Child Welfare Act, it's actually responding to a pretty troubling, devastating history of federal, state, and nonprofit regulation of Indian families. The regulation of Indian families I'm talking about are removing Indian children for the purposes of sending them to boarding school, sometimes without the free consent of their parents. Sometimes it was coerced consent. What I mean by that is a BIA person might tell you your community doesn't get food unless you send your children away to this boarding school, and also through adoption. But the goal of what these programs were to assimilate Indian children. So by looking at the family, regulating the Indian family, the goal was that eventually we would terminate Indian tribes. We would get rid of those Indian tribes because Indians would just become Americans. So that's the history there. And like I said, this targeted specifically Indian children, Indian families broken up and removed from reservations. Well, by the 1970s, there's a lot of, remember, this is the decade of change. So you have a lot of people coming hot out of the civil rights movement, just got out of law school, going to represent people up in North Dakota, and finding some really, really disturbing things happening. North Dakota, Washington State, Minnesota, those were some of the prime, shall we call them offenders, or the ones that get a lot of airtime when Congress is considering the Indian Child Welfare Act. Because by the mid-1970s, approximately 25 to 35% of all Indian children had been completely taken out of their homes, 90% of those out of the community. So to just sort of highlight what's going on here, they're removing the kids in order to destabilize the tribes. So as an attack on the tribal government, we're taking the kids, we're sending them to boarding schools. By post-World War II, we're adopting them out to non-Indians. So Congress responded to that history to advocates with the Indian Child Welfare Act in 1978. So in certain types of child custody proceedings involving Indian children, ICWA applies. So a child custody proceeding here would be anything that's adverse to one or both parents' rights, foster care, child abuse and neglect proceedings, adoption. And an Indian child, as we discussed earlier, is someone who's enrolled in a federally recognized tribe or eligible for enrollment. ICWA also provides for heightened protections to prevent the breakup of the Indian family. So when I say heightened protections, these cases are still happening in state court, just like any other abuse and neglect proceeding would. However, ICWA requires that states conduct inquiry as to whether or not the child's Indian. They have to ask that in every case. And if the child is Indian, there are some actual heightened standards that we have to look at. For example, we need a qualified expert witness who is familiar with that child's tribal culture to tell us what the child rearing practices look like in that culture, and also whether or not this child's in harm. It also provides replacement preferences This is the thing it's most well known for. This is why a lot of child welfare advocates like ICWA are the placement preferences, which, and here's why they like them. They prioritize family. For a lot of us, it's very intuitive that if my niece or my nephew, something happened and they had to leave their parents' home, that they could come live with me. It's very intuitive. But in a lot of these cases, that is not what happened at all. Even today in non-ICWA cases in a lot of places, that does not happen at all. Children who are removed from their homes end up in stranger foster care, which is simply not good for those children in most cases. So that's one of the reasons people, particularly advocates, like, or one thing they like about ICWA is the idea that if we have to take a kid out of their home, we try to place them with their family. If we can't place with family, then we look at tribal preference or tribal placements. So are there placements within the tribal community to keep the child connected to their tribal culture to place them there? And also this really important piece for tribal sovereignty, which is tribal intervention and participation in these child custody proceedings. This is in the best interest of Indian children, primarily because it helps make sure those cultural ties are maintained. That's from the child aspect of this. And from the government aspect of this, this is how the US government ensures that the trust responsibility it owes to Indian tribes is fulfilled by ensuring that tribes can maintain their membership and maintain their member children. So I won't read all of these to you given the time, but the role of the tribe in an ICWA case is to make recommendations on the case, placements, so to provide placements if the child needs one, if they need to be removed from their home, and also culturally appropriate services. So providing, let's say, substance abuse programming. Housing is a very big issue. And this is where I should probably tell you this. Approximately 75% of all child abuse and neglect proceedings are neglect cases. The reason this distinction matters is because when we often hear child welfare case, state involvement, there's this connotation that we're talking about parents who are physically abusing their children, they're dangerous people, they're bad, all of these really negative things. In a large number of the cases, we are looking at neglect. Not that neglect is a good thing or that it's an okay thing. The reason that's important is because neglect typically stems from conditions associated with poverty. Things like mental health, that sort of things, where neglect usually stems from. So a great example of neglect is houselessness. If a parent doesn't have a home, that's a form of neglect in a lot of jurisdictions, or it can be considered a form of neglect if there's state involvement. So by allowing tribes to participate in this process or affording this mechanism for tribes to participate, tribes are able, in cases where this is possible, because if a child is near their tribe, this works a lot better than if a child is across the country, but it allows the tribe to get involved and provide culturally appropriate services to try to get the parent into housing, substance abuse programming, medication, that kind of thing. And I already went over this with the placement preferences, but like I said, this is what people, I think, know ICWA for, what child welfare organizations consider ICWA as a gold standard for, is because in the event that I do have to remove a child from their parents, sort of a path of the least amount of harm is to place them with grandma, auntie, cousin, whomever is related to that child, and or a cultural or a tribal placement first before we start getting into stranger care. So I also want to address quickly what ICWA does not do. It doesn't ignore a child's best interests. I hear from a lot of folks actually that, ICWA denies a child's best interest hearing, and that's actually not true. because the role of the tribe in an ICWA case is to meet the child's best interests. The child doesn't have to go through the state best interest process, which is controversial among child welfare advocates for a few reasons. It doesn't allow, bad parents to keep their kids. Some people think that, or not some people, but there are critiques that ICWA, allows bad parents to keep their kids. It doesn't take away kids and it puts kids in danger. I will tell you that regardless of if that parent is Indian or not, if the child's in danger, if the parent's not complying with what they need to do, the state will take them. The state will terminate their rights. Sometimes the tribe will agree. Oftentimes the tribe doesn't agree, because my understanding is that for many tribes, the termination of parental rights, which is a very modern legal standard, believe it or not, this is not something we've always done as a country. But the idea of terminating a parent's right goes against culture. And there's a lot in the child welfare world about whether we should ever be doing this in the first place. Because like I said, it's a modern invention since about 1980 or so in terms of this type of child welfare program. And it doesn't allow tribes or anyone else to derail these proceedings, because there seems to be a little concern that by allowing tribes to participate, they derail the proceedings, or, let's say the state takes the kid from mom, then the tribe's going to give him back. That's simply not how that works. So the case that's before the Supreme Court, Holland versus Brackeen, this is a constitutional challenge to ICWA for three things. First off, this goes into what does Indian mean? But whether or not ICWA is a race-based statute. In the US, we have the 14th Amendment. Actually, we're looking at the 5th Amendment here. But the 5th Amendment, let's go with the 14th Amendment, because the 14th Amendment has the language that we use here. But we have this thing called the Equal Protection Clause, meaning that we are all owed the equal protection of the laws. So historically, think of Brown versus Board of Education. That is the theory under which Brown versus Board of Education held that, the separate but equal school system just didn't work. It was unconstitutional. But you can't make these race-based laws unless you have a really good reason. And so that's the challenge, is that ICWA is a race-based statute. Now, historically, as I told you, American Indian has been considered a political status, not one based in race, because it's about the child's tie to their tribe. So I just wanted to highlight sort of the challenge and what we have historically understood Indian to mean and the theory behind ICWA. Whether or not Congress was ever allowed to pass this because of its trust responsibility, the argument here is that tribes should be limited to only governing their specific area. So like their specific reservation, that's it. And then sort of one of the problems with that, as I mentioned, 70% of American Indians live off reservation. That doesn't mean they all live super far off reservation. A lot of folks live in what we call border towns. Good example of this is the Nez Perce Reservation in Lewiston. And that's a pretty common one, border towns. And then whether ICWA violates states' rights. So see, when I was with Castro Huerta and I said, oh, this is some really scary language, we do see a states' rights argument being made here. Because historically, Congress has passed statutes about child welfare law requiring states to have certain laws on the books in order to get funding. But generally speaking, things like family law, child welfare law, child abuse and neglect, adoption has been left to the states to make laws about. And so that's sort of the challenge there, is that, well, ICWA is making states implement these protections and making them have tribes participate and disrupting adoption, in contrast to what state law is, and it's trying to supersede state law. So those are the three main arguments about ICWA in that case. I cannot tonight tell you what's going to happen. I can tell you that we heard oral arguments on November 9th, or we listened to them. I was not in DC. And we can have a decision anytime between now and June. But I have to tell you what that means in Washington. In Washington, we do have a state ICWA law. So we have the federal statute, or actually, let me do this. We have a federal statute that provides a bare minimum. And then in Washington, there's a state statute, a state law that provides even more protection for Indian families and kids. Now, if the Supreme Court says the federal law is unconstitutional, in Washington, we will still have a state law that has ICWA, a state ICWA law, unless ICWA is unconstitutional on the grounds that it's a race-based statute, or unless the state legislature repeals the law, which could happen, or it could not happen in Washington. However, I have heard rumblings that some folks are afraid that in some states, because 9 states have an ICWA law in addition to the federal law. In some states, there have been rumblings that perhaps the state legislature might repeal the state law if the federal law goes. So that's just sort of what this could mean in Washington. But we would have a state law. So I apologize for going over, but are there any questions? I know I didn't take any questions during the ICWA part. I'm happy to take any.
I have a question. I talked to you earlier about this podcast, or this article that I read about this woman who does the podcast. And one of the subjects they touched on was whether this would have, deciding if it's, race-based or the other thing. Anyway, would make changes on for gaming, for casinos, if it would have greater ramifications than just child welfare.
Mm-hmm.
Is that something that your world is talking about?
Definitely, yes. So the greater ramifications would be with the equal protection with the race part. Because as I mentioned, there was a case in 1974 called Morton versus Mancarey, in which the U.S. Supreme Court said Indian is a political status, not a race. That's sort of the bedrock of modern Indian law, which is that Congress passes laws pertaining to Indian tribes and to Indians because of that political status. If the Supreme Court now says Indian is a race, ICWA will fail, gaming statutes will fail, potentially natural resource related statutes will fail. Anything and everything could fail because if it's considered a race as opposed to a political status. Because what's really super interesting about the Equal Protection Clause, in its origin, it was meant to protect newly freed enslaved Africans, to make sure that states could not discriminate against them. But we know that didn't actually happen because after the short period of Reconstruction, we went into the era of segregation, where separate but equal was okay. Mm-hmm. But that's what this Equal Protection Clause was originally meant for. That's what that was all about, was ensuring that newly freed enslaved Africans could have the protections of citizenship, and that they could have due process and equal protection of the laws as citizens. But we have seen equal protection be used in this way numerous times, actually. It's the same theory that's in the affirmative action cases as to whether or not schools can look at race, anything to do with race, in admitting students. That is the theory, or that is the law, that is the challenge in those cases, is whether or not that is violating the equal protection of the laws. So another question, my concern is a potential application to other sovereign issues of ICWA is determined to be unconstitutional along states' rights. Yes, so that's a great point, Carol. And that is why I highlight Castro Huerta. Because after the Castro Huerta decision, a lot of Indian law folks, I think we mostly agree that that's limited to Oklahoma. It's limited to that McGirt, or it's responding to that McGirt situation. But the language is very concerning, especially when that challenge comes up here in this case. And we are wondering, how will the court look at states' rights here? Because the reason that ICWA is a little bit more vulnerable than other child welfare law is that other child welfare law is tied to funding. What I mean by that, Title 4E of the Social Security Act provides funds to states for child welfare. However, in order to get those funds, states have to meet certain requirements. That is perfectly constitutional under what we call the spending clause, meaning Congress gives you money, therefore you got to comply. It's, strings, right? Unfortunately, ICWA did not get tied into that funding. And it seems there were some political reasons behind it. One of my colleagues has done a little historical research on that point. But I think this is another important point to highlight. ICWA was one of the first child welfare laws because the very first federal child welfare law came in 1974. That's called the Child Abuse Prevention and Treatment Act. It basically didn't do a lot other than start providing funding to states and requiring that states get abuse and neglect laws on their books. Because at that point in the 1970s, not every state had child abuse and neglect laws. 1978, ICWA is passed. 1980, that's where you start to see the first requirements that states actually have to impose to get funding. So specific findings that they have to make. So that's what makes ICWA just a little bit more vulnerable than general child welfare law, is because it's not tied or connected to Social Security funding that the states would have to comply with in order to receive that funding. Any other questions I could answer?
Okay, well, thank you. This was fascinating. And just for your information, for your students, for whoever may be interested, in another week or two, this will be, the recording will be available on our website. So, feel free to send people there. So.
And I see there's one more sort of question in the box. Okay. Any predictions about how it will go? Not really. I don't feel terribly confident because of the states' rights piece. That's specifically the states' rights piece is why I feel not so confident, given what we saw in the Castro Huerta decision, given just sort of, and I say this with a small c, given how conservative the court is reading the Constitution. And what I mean by that is getting back to just super basic principles of the Constitution. And reading the Constitution. A great example would be the Dobbs case, in which the court said, we're actually going to go all the way back to Roe and make sure it's right, and that we agree that it's right under the Constitution, and we're going to review it all. And it's a very strict, again, small c, conservative reading of the Constitution. We have a phrase for that, which is called originalism, and reading the Constitution and how the framers would have originally intended the document to be used. Treaties with Indian nations, tribes, long preceded post-civil amendments. Does that make a difference with this court? It could, but the thing is that ICWA does not exist by treaty, it's by congressional statute. So a treaty might supersede congressional statute, But the treaty era ended long before Congress contemplated passing ICWA. So I'm not entirely sure about how this court might interpret treaties. But generally speaking, treaties have been pretty narrowly interpreted. I do know there are justices on the court, such as Justice Thomas, who've previously written, to maybe give you a hint about how they might think about this, written phrases such as so-called Indian law, so-called Indian law. So there have been, this is not, Castro Huerta certainly wasn't the first time that you could sort of see that there are people on the court who either don't understand Indian law or don't think that Indian law should really be much of anything, especially off the reservation or anything like that. So yeah, that's, I think one of the things that makes this interesting is we saw what they did in Castro Huerta, but there's no guarantee that that's how ICWA will go. But I do think that this case could help us understand what they meant in Castro Huerta, because a lot of my fellow scholars, we do have debate over what Castro Huerta means, even if we don't like the language. You know, maybe it's limited. Maybe the court won't consider states' rights that way, and they might consider states' rights that way. We don't know.
Thank you.
Anything else? Anybody have any other questions, comments?
Thank you. It was very interesting.
Very interesting. Yes.
Yeah, thank you.
Okay.
Okay, I'll stop recording.
Thank you.
Okay.
All right. Well,